Hello. On behalf of the Arthur V. Mauro Institute for Peace and Justice at St. Paul's College and the University of Manitoba, welcome. My name is Dr. Katarina Standish, and thank you very much for joining us today. I'd like to begin with an acknowledgement that we're having this conversation today on Treaty 1 territory. We gather today in a space of conversation on the traditional territories of the Anishinaabe, Cree, Oji Cree, Dakota, and Dene peoples, and the Métis Nation. Today's Brown Bag Lecture is taking place both in person and online, and our lecture is being recorded for future broadcast on the Mauro Institute YouTube channel. So this lecture will include 30 to 35 minutes of a presentation, followed by a question and answer period, and online viewers are requested to type their questions into the Q&A box on the Zoom platform. So before we begin, can I encourage you please to visit our website to see the descriptions of all of our brown bags, past, current, and in the future, and there you will find registration links and reportings. Our final brown bag for this year is titled Extremism, Terrorism, and Misogyny in Canada. So as a final point of interest, we ask you to consider making your calendars for the 2023 Sol Canny Lecture for Peace and Justice, featuring Lieutenant General Romeo Dallaire. His lecture, Peace, Faith, and Humanity in Times of Crisis, will be held on Thursday, November 9th at 1:30 in the Manitoba Room, University Centre here at the University of Manitoba. And this lecture is an in-person only live event. So our lecturer today is Dr. Michelle Gallant, professor in the Faculty of Law here at the University of Manitoba. In addition to her position as professor in the Faculty of Law, we are very pleased to count her among the members of the St. Paul's College Assembly and as a great friend and contributor to the Mauro Institute and its programs. Dr. Gallant earned her BA at the University of Prince Edward Island, her LLB at the University of New Brunswick, and her LLM at the University of British Columbia. And her Doctor of Philosophy was achieved in 2000 at the University of London. Dr. Gallant teaches on a wide range of subjects and teaches in areas including global and domestic governance of tainted finance, income tax law and policy, law reform, philanthropy and the law, and financing of terrorism. Today, Dr. Gallant will be looking at the legal implications and definitions surrounding the rights and limitations of civic protest in the context of the 2022 Convoy protest, the invocation of the Emergencies Act, and the subsequent government inquiry. We are extremely pleased to welcome Dr. Michelle Gallant to the Brown Bag Lecture podium. Dr. Gallant.
Thank you, Dr. Standish. Thank you to each of you for your participation, both in the room and online, for making space in your busy lives to be here. Again, also thank you to the Mauro Institute on Peace and Justice for this opportunity and for organizing the Brown Bag series. Any invocation of emergency powers is an extraordinary event, any invocation. Emergency powers, however, do not suspend the rule of law. Constitutional norms, charter norms continue to exist. The difference would be that in times of emergencies, discrete and temporary limitations on rights and privileges come into operation. Temporary laws come into operation. I would also note that everyone has a perspective, an opinion on the emergency situation in February 2022. Your perspective on this event may differ depending on where you lived. And that goes as basically from whether you lived in the center of Ottawa, whether you lived on the Ottawa outskirts, whether you lived in northern Quebec, whether you lived in Newfoundland, whether you were lived on the border in Alberta. But it may also be dependent upon how the impacts of the pandemic on your actual life. If you lost your job and were displaced, that might have had impact on how you felt about the protest movements that were happening across the country. So simply to say that everyone has some sense of a perspective. But what I wanted to do today is to simply chart the relationship between law and the emergency, to simply sort of outline how those two things connect, the importance of what I might say, what a rule of law might be in this context. And full disclosure, yes, I did have some involvement with the Public Order Emergency Commission, which is the commission that was convened under Section 63.2 to deal with, to analyze what happened. So full disclosure, I did have some involvement there. However, nothing that I'm going to say today is confidential information. Everything I say derives from what's publicly sourced information. You can find everything I say either anywhere in research papers, in the court system. And I would note that a great treasure trove, if you want information about what happened, about the emergency and about the analysis, the Public Order Emergency Commission actually has a website. And if you look at that website, there's a treasure trove of information, of data. It's a record of history. If you can go through it, if you figure out what different positions, it's amazing, because when I think about that, one of the things that it has is it has 6 weeks of videoed information, videotaping, right, of the hearings. And so if you are wondering, I wonder what our federal ministers thought, well, you can hear them. You can still go online and you can watch. They're answering questions, they're answering lawyers' questions, right, which can really be annoying. But it's an amazing record of what happened. So I would continue, if you remember nothing of what we talk about today, simply to look there, because to inform sort of your own understanding. You may not agree, you may grossly disagree with everything that's said, but it's an extraordinary research database for anyone, and a place to sort of find out something. All right. Okay, so this is just how I'd just like to go through today. To say a few things about why the event matters, why it was sort of a historic moment, to say a few words about the rule of law, and then to speak more specifically about the rule of law in the context of emergencies in this particular use, and then to say a few things about the financial piece in law, because that's sort of the piece that holds more interest for me. And hopefully, well, as Jason said, or as Dr. Standish alluded, there'll be some time at the end, so I would welcome your comments or questions. So first of all, as a historic moment, yes, it was a historic moment given that it was the first use of the Federal Emergencies Act since its inception. So we've had emergencies law, this particular act, on the books since 1988, but this is the first time it was actually used. You will note that there have been various uses of provincial emergencies law. So the provinces and the territories have their own emergency powers. Typically, they might use those in the context of a disaster, so a flood, forest fires, think of BC and the hurricanes last year on the East Coast. Those provincial powers have been invoked, but this particular one, because it's a federal one, has not been invoked since 1988. This is the first use. And if in thinking about sort of historically, it is true that there's a relationship between the Federal Emergencies Act and the War Measures Act. The War Measures Act is usually sort of seen as its ancestor. If you're a little familiar with history, or you might have been alive when some of this happened, but the disturbances in Quebec in the early 1970s, and that's where there was the invocation of the War Measures Act. Those acts actually led to the death of a minister and the kidnapping of a second, and so they invoked the War Measures Act. But after that incident, they decided that we need a better instrument. Now, maybe this instrument we have is not the greatest, but it's certainly a better instrument than the War Measures Act. So it's the first use of the act, and that makes it a very sort of historic moment. Also, see if this is gonna.
Apologies.
It's all right, it doesn't seem to be moving to the next one, but.
Should be now.
There we go. Okay, so the second point I want to make just at the outset is that this is a historic, in terms of historic moment, it's a national event, right? It is a national event, only in the sense that if you, for example, here, there was a convoy here that settled in Winnipeg. There were convoy movements in British Columbia. They were in Alberta. They were in Nova Scotia. There were participants also, right, from coast to coast to coast. So it was, in that sense, it had interest. It certainly drew interest and responses from across the country. And again, you didn't have to agree. You could have been on either side. You might have, thought that agreed that been for or against what was happening, the protest. However, there was this kind of engagement from coast to coast. And the second piece I think that makes it a national event was this idea that it galvanized or it highlighted or it popularized a bunch of discourses that were already happening. So if you sort of look and you think, well, one of the things that popularized sort of nationally is that people, this idea of the discourses on information, misinformation, disinformation, the use of social media, those discourses were happening, but they never got such attention as they did in relevance, as they did and sort of popular consciousness of these as they did at that time. Also, what you saw in terms of popularizing discourses, there was also, previously there were discourses about cryptocurrency, what should we do about a few things about, a state-backed digitized currency, all kinds of fundraising through non-typical venues, fundraising and technology, all of that was happening, but this sort of nationally kind of heightened interest in those. And finally, and of course, it heightened, popularized discourses on rights and freedoms and fundamental freedoms. One of the things that we talk about in law school is that generally my freedom to to punch you in the chin ends at your chin. So the idea that we have freedoms and we have rights, but there are limits on those. So I think another thing is a national event. It highlighted or popularized these kind of discourses. And really, really importantly, and I think sometimes we forget this, is that February 2022, even before the Emergencies Act, that whole thing, it attracted international notice. Canada doesn't always sort of have much of an identity when you move beyond our borders. Nice to think we do, but you don't hear much about it, when you're vacationing in Australia or in, New Zealand, or if you're, down in Uruguay, you're not going to hear about it. But this particular thing, it actually drew international notice. So in terms of, here we see, this is El País, this is, the Spanish newspaper, and sort of basically saying the Canadian protesters basically have Trudeau on the ropes. We have a boxing analogy here. But you also saw it, right down through Argentina, here saying that in the House of Commons, the Canadian Prime Minister Justin Trudeau is accusing the Convoy of blocking democracy and blocking the economy. I like this one in particular because this one from New Zealand, we think about international notice. When you look at this line in the middle there in New Zealand, these huge protests inspired by the freedom convoys which began in Canada, right? So this idea that there were convoys and they were notably inspired by what was happening here. So that kind of international notice. So international notice has been good and bad, but simply, right, this is now part of our identity. It eclipsed other kinds of things that we might do in terms of attracting that kind of international notice. So I have time, I'll come back at the end to why that's really, really important. So in shifting from that introduction, just talk about why the rule of law matters. I would simply say this. In any context that we speak about, why does the rule of law matter? Well, because the rule of law shapes determinations of legitimacy, of right and wrong. So you're not going to be able to say to someone that was right or wrong unless you have some sense of what the law is, right? It gives you some sense. You don't have to agree with the law, and the law can be changed. But one reason we talk about law, we have sort of a sense of an ordered society. We have laws, we comply with them, we use them as standards. You may hold someone up and say, have you met the legal standard or not? And that's exactly what the inquiry into the Emergencies Act did. It was about sort of holding it to a specific standard. But the rule of law really does matter, because without law, we have no order. Right? You have no order, no way to discern, no standards. Again, you might not agree with the standards, things might change, right? You might not agree with the level of order, right? Maybe, society is collapsing, but law is one sort of defense against that, right? This idea of an ordered rule of law. All right, so in thinking about why the rule of law matters, the rule of law and the Emergencies Act, specifically the Emergencies Act and its use and its invocation in 2022 in response to the protest, is circumscribed by law. There is an Emergencies Act, so we have it right here, right? An act to authorize the taking of special temporary measures, right? What we said, that's the context of emergency, to ensure the safety and security during national emergency. So all of what happened in thinking about the invocation and in invoking it and in its aftermath, right, was conditioned by law. That's not the same as saying it was in compliance with law. It's simply saying that there was a legal framework, right, that governed the invocation. So when we think of things like what does this act do? I'm going to go through a few of these, but it prescribes the conditions that have to exist, the standards that have to be met, the thresholds. It tells you that these powers must be temporary. So all of those things that happened, right? It also tells you things like there must be supervision. There must be supervision during the event, post-event supervision. So all of those things are conditioned by law, by the Emergencies Act. Okay, so I just want to talk about what a few of these are and why they may, why they're important. So emergencies law, then the Emergencies Act contains 4 emergency powers, right? 4 emergency powers. The one invoked here was what's called a public order emergency. So public welfare emergencies, that's usually your, fires, floods, and disasters. International emergencies are threats to our sovereignty posed by external states, and war, I think, is self-explanatory. But all this to say, the idea of the power that was invoked, the public order emergency power, if you're going to ask someone what is specifically defined in the Act here, what's a public order emergency? And it says right here, an emergency that arises from threats to security of Canada and that is so serious as to be a national emergency. And the next question for the lawyer is, what's a national emergency? Well, it's right there in section 3, right? A national emergency is one that seriously endangers the life, health, security of Canadians. This is of such proportions that it exceeds the capacity of a province, right? Or that seriously threatens the ability of the governor the government of Canada to preserve the sovereignty of Canada, and that cannot be effectively dealt with by the province. So just in thinking about, right, what the rule was, these are the parts that it had to comply with. And I just added this top piece here you see on the left where it says activities within or related to Canada directly. I added that because when you think about some of the debates about the legitimacy of the use of the security of the Emergencies Act, one of those debates centered on what threshold you had to meet, what did the threat have to be. Now we see right here, public order emergency, you see where at the last line it says threats to the security that has the meaning assigned by CSIS. Here on the side, that is the meaning assigned by CSIS that the government said it relied upon. So just in thinking about, did you actually, what were you relying upon when you made this declaration? The claim here was that these activities, right, we're relying on this particular threat, that the activities within or related to Canada directed towards the support of the threat or use of serious violence against persons or property for the purpose of achieving a political, religious, ideological objective within Canada or foreign state. So that's the specific justification upon which the government relied, which is really important. There are other justifications. One of them is, I think, is treason. I'm trying to think about the other 4, but there are 4 contexts. One of them is foreign interference. That wasn't relied upon. This is the one that relied upon, and particularly in thinking about the rule of law, because this was a convoy movement. So if it began as a protest, we're entitled to protest, we're entitled to political dissent. So in that law, it's specifically prescribed by law. It says, by the way, all of these activities, right, designed to achieve a political, religious, or ideological objective, right, specifically does not include lawful advocacy, right, protest or dissent, unless carried out in conjunction. So in terms of law ruminating on, okay, in 1988, thinking about what would this law be used for, what's a public order emergency going to be used for? Protest, lawful protest. So the idea of law seeking to accommodate that right within itself, right, you see it here. Again, we can all disagree, and you can say a debate centered on all aspects of these throughout, right? But at least there's a standard against which we can think about and begin to measure some of these things. So just moving from these, right? I just want to cover a couple more. This one, this is the Governor and Council. This is Section 17 of the Emergencies Act. What does it say? This is what the Governor and Council, who's sort of the Prime Minister and his cabinet, believes. You have to believe on reasonable grounds that a public order emergency exists and that necessitates the taking of special measures. But simply say here, in terms of law shaping the decision, right? It's not enough for me to say, I believe. you have to have, in terms of law, law has decided what do reasonable grounds to believe mean, and it means both a subjective belief, yeah, I or we believe, but also an objective. On objective grounds, are there objective grounds for that belief? So and this is clearly sort of just in thinking about the legal ramifications here, right? It has to be based on something reasonable. We can debate as to whether the evidence was sufficient to say there was a subjective reasonable grounds to believe or not, but it's circumscribed by law, seriously circumscribed by law. And so I wanted to, and the other piece I just wanted to mention here too, because I have this consultation. So you remember when this event was happening, there was a lot of debate about consultations, and late on a Sunday night and early Monday morning, there was a meeting and that allegedly involved, not allegedly, that involved the provinces and the territories, consultations. And then somebody later claimed, well, you didn't consult with the First Nations. All of this, in terms of the security, in terms of the Emergencies Act, specifically calls for you must consult. And it identifies the parties you have to consult with, and that would have been the provinces and the territories. So in thinking about law, it doesn't say adequate, it doesn't say how much consultation, how long do you need, a week, whatever. It simply says you have to consult, and that's a requirement here. It does not say specifically, unless I missed it, that you have to consult with First Nations groups. But maybe that is something that we would want to change in the law and mandate that, right? But in terms of compliance, that wouldn't have been, to the best of my knowledge, an ingredient that had to be satisfied to say, yeah, this, the invocation of this is okay. So another piece that I just want to talk about is I do think these are really important. When you think about using any kind of emergency power, the question comes up about where's your accountability, right? Accountability. Now, certainly there's accountability. We talk about political accountability. If you, I suppose if you always operate by emergencies, at some point in time, your government's going to fail. So that's a fail-safe instrument. There's voting, elections. That's an accountability mechanism. However, with respect to specifically Emergencies Act, it does countenance supervision, right, while an emergency is declared. So once an emergency is declared and measures have been invoked, immediately it says, look, there has to be one of those accountability mechanisms is ensuring a parliamentary committee. So if you watched, once the declaration was made, immediately you could watch. The first committee meetings were not public. There were later committee meetings that were public, and you can watch those. But the idea was, as soon as it was invoked, there was a parliamentary committee, joint committee, who was watching and studying and investigating already, on the day after this came into operation. And the second accountability mechanism I point to would be the Public Order Emergency Commission. And why would that be important? Because that means if I'm a prime minister and I'm thinking about using an emergencies law, I know right at the outset that if we choose to use this, I have to, by law, Section 63, after the emergency is over, call a commission to investigate exactly what I've done. So in terms of an accountability mechanism, it's this idea that in terms of constraining your use, you're going to be thinking, I can do this, and there's political accountability, but there's also this commission. So again, you can, and I would encourage you to read, what the commission actually thought about this event. And the idea isn't that, the commission's going to get it necessarily right, necessarily wrong. We can fundamentally disagree about the conclusions of that commission, but the idea would be it's ordered by law because you know that this is going to happen. Whether you like it or not, there's going to be a commission that's going to investigate exactly what you've done. So I want to spend a few minutes, I'm not sure how much time I have left, but I want to spend a few minutes. Okay, that's the general parameters of how the exercise was sort of conditioned by the Emergencies Act. So all of these things meaning that the exercise had to sort of fit within these parameters. So I want to turn now a little more specifically on the funding and the finance dimensions. So I want to talk about sort of 4 of these and how they in turn were also shaped by law. So I want to talk about foreign funding, funding of the convoy, attempts to thwart the convoy funding, as well as the Emergency Act orders. Why do I think that's important? Because in a minute, if you look at what was the response, once an emergency was declared, we introduced special powers. What were those special powers about? If you look at the content of those special powers, probably 75% of them were restricting finance. So there was this finance-centric core, which I think is really important. So this one thing is the declaration, was it legitimate or not? But secondly, what powers did you use? And in this particular case, intensely finance property-centric powers. Okay, so just let me say a few things about, I'm gonna collapse foreign funding concerns and funding of the convoy. Just in thinking about the foreign funding concerns, everyone is aware that in sort of the cacophony and the build up to the invocation, there was a lot of discourse. People were talking about there's foreign interference, foreign interference, foreign interference. So that was part of newspaper reports. The only reason I have here the sort of, this was up on, it's still up on the NDP websites. It's not to slight the NDP or anything, but it surprised me. Because this went up before. People were talking about the influence of foreign financing on the convoy. Why does that matter? Because Canada's supposed to be a sovereign nation. Do we actually have foreign interference everywhere? Direct foreign investment, soliciting money from abroad to invest in the Canadian industrial sectors, that's foreign interference. Or it's foreign investment, depending on how you see it. So there's lots of foreign influence, foreign money flowing in. But I'm simply outlining here is that this was sort of a particular bone of contention and sort of infused things. It surprised me that this website went up because at the time, it wasn't particularly well known. It wasn't, so there wasn't an evidential basis. There was a leak, which suggested something, but there wasn't a strong evidential basis to say that this was anything other than a Canadian homegrown initiative. And so in part of that, right, so I'm thinking about those, collapsing again these two together, foreign funding and funding of the convoy. The foreign funding was this idea, it was the foreign funding of the particular convoy movement. And as I said, it mattered because we do restrict foreign funding, particularly in the context of elections. You cannot have foreign funding of a political, of an actual political party. Elections law says that specifically. There's a few other Canadian laws that prohibit some kind of foreign funding, but that's why it was contentious. So the whole question was this convoy movement undergirded by this foreign dimension? And all I would say is this legal excavation that we've seen since, right, has given, if not a full portrait, it has, this legal excavation has provided some facts on which to say, yeah, there was some foreign funding. So when I say that, I'm simply thinking, I have here, this is a report by the commission, which was specifically about what can we do, how can we map or chart what we know of funding. So what you would heard in the, everybody would familiar with how a lot of the funding happened. A lot of the funding was through what are called crowdfunding platforms, crowdfunding vehicles. Some of the funding was direct into accounts, so e-transfers, we're all familiar with those. So in looking at sort of the funding and the foreign, specifically the foreign question, they did find, so on the GoFundMe, which was the crowdfunding platform that actually closed at the end of January, when they did the excavation of the information that was available there, they did find that 86% of those of the money was Canadian sourced, right? So 86% was here, I think 11% was the US and the rest elsewhere. But they also found, so that was the GoFundMe one. They also found in terms of e-transfers, where were those coming from? So a lot of the e-transfers, which went directly into personal bank accounts or even into trust bank accounts, they did find that I think it's 87% of those were at least domiciled, at least came through or seemed to have Canadian origins, come through a Canadian financial institution. However, Give, Send, Go, the other platform that was used when GoFundMe shut down, there they did find what I would say is facts of some, at least, foreign funding, and I must admit, surprised. On the specific Freedom Convoy Fund, which was maintained, they found that 35% of the donations there were Canadian sourced, but actually 59% were US sourced. They also found, and 6% other. They also found Adopt a Trucker, which was another venue that was used. Again, 43% of the donations originated in Canada, 51% from the United States. So at least you've seen through this that maybe at the time there wasn't there was a lot of cacophony, as I said, about foreign fundings, but this kind of legal mechanism sort of allowed for some some sort of sifting through the detritus and finding out, yeah, there was some, at least some foreign funding. Always when we say foreign funding in Canada, we usually mean the United States. So I wanted to highlight, there were also, just in terms of foreign funding, there was a lot of cash. Cash is the most untraceable thing that you can use, sort of next to some digital currency. So there was no real sense of where did the cash come from. It seems that it was just people walking around and handing people money, which is fair enough, right? And it also, if we look at sort of the foreign funding, the funding of the Convoy, they also do talk about there was some, digital currency was used. They did set up a coin, and with those ones, it's a little more difficult to think about what are there, where are the foreign connections, because to some people maybe digital currency doesn't inhabit any sense in which in law you would understand as sort of a difference between foreign and domestic. It inhabits a world that's sort of elsewhere. So just in continuing on this thematic of the foreign funding, I would be remiss if I didn't talk about, just to step outside of the emergencies work around funding, but just to focus on this. There were attempts to thwart the funding that had nothing to do with emergency law. They were lawful too. So the law gives us a lot of instruments we can use. And these instruments were used for better or for worse, whether we agree or disagree. So the province of Ontario did unusually bring this weird, strange action to forfeit money based on the fact that was offense-related property. Usually you'd think of what's offense-related property in AK-47, but in this case it was specifically money was the offense-related property. The province did consider suing using civil forfeiture. What is civil forfeiture? That's just an instrument that exists, and we say, listen, on the basis of balance of probabilities, we think you engaged in something unlawful, we can take your stuff. They didn't ultimately, they did consider it, but most importantly too, quite outside of emergencies law, there were public and private law injunctions. So these weren't state authored acts, these were individuals. And one of the important things to think about in terms of money, so these injunctions were one of the injunctions that focused on noise. So an injunction to stop this public nuisance, a lot of noise and honking. But as part of those injunctions, they sought what are called Mariva injunctions, seizing the donations. Now, why would they be seizing the donations? This is the important when you think about the right to think about protest and accountability. We all do have the right to dissent, the right to advocacy, to protest. But my right to protest, as we said, your fist in your chin, if my protest disrupts your life, you equally have the right to use the law in response. So these initiatives that were commenced here, I'm just sort of decide that to me they're very, very troublesome. The public and private law injunctions seizing money simply because of this, because what they're trying to, they're seeking to hold the individuals associated with the public to publicly account, financially account for injuries were caused, and the reason that is a bit of a difficult, dangerous, to me anyways, territory, is that any kind of protest will cause some kind of disturbance. So how do you, even a minimal one, right? And any minimal disturbance. So I just highlight it again. I just highlight that it seems to be there might be a bit of a dangerous precedent beginning to evolve there. That's all. All right. So I want to talk specifically about these. These are, what did we do with the Emergencies Act? Under the Emergencies Act, when it was invoked, two specific things. They're really short. Emergency measures order regulation and the emergency measures economic. They're really short. They were executed under Section 19, and I'll come back to Section 19 in 2 seconds. But basically, if somebody said, what laws did we do? What did we do? We focused on property. So if you look at both of these orders, they are intensely property-centric. So things like, so what do these orders and measures do? Well, one of the things that they're a prohibition on the provision of property. So if I said to you, what is the provision of property? Property is a bottle of water. So in terms of providing a bottle of water to somebody who's engaged in these protests, let me start by saying prohibition on the provision of property. Let me start by saying both of these orders, the first order actually prohibits the activities. So suddenly whatever was happening is under these temporary orders, right, unlawful. It's prohibited and there's a penalty that makes it unlawful, right, period. So once it was prohibited, the provision of property, which as I said could include a bottle of water, was prohibited to somebody who's involved in these. What was also prohibited? So financial entities, right? So if you are engaged in this particular action, since it was prohibited, if you were engaged in it or facilitating financially, you would become what's called a designated person. So if I was down there and I was doing something all of a sudden, and I'm engaged directly or indirectly in this prohibited activity prohibited by these new laws, designated person is defined by these new temporary norms. If I'm actually doing this, I'm a designated person, and therefore, these kind of financial restrictions. So look at the one, financial entities have a duty to cease dealing with property controlled or held by, if I'm a designated person, by me. So my bank has a duty to look and see if any, and to cease dealing with any property held by me. That includes a mortgage, that includes a student loan, that includes anything. Financial entities had a duty to determine. So all of a sudden, the Toronto Dominion Bank has a duty to look and see, hey, do we have that person's stuff, right? Which they usually would not. That's financial regulation. I said it's centered on property. And financial entities have a duty to disclose to the RCMP the existence of your property. So yes, these measures said things like, if you're asked to provide a tow truck, you're compelled under these laws to provide that kind of assistance. They did include those kind of services and that kind of help, right? They did include that. But if you look at in bulk, they're intensely centered on your property, on your financial stuff, right? So when we had the War Measures Act, that kind of, in terms of dealing with that kind of disturbance, right? There was nothing of the kind that was ever used, and there was nothing of the kind that was even contemplated. But here, you have this intensely finance-centric approach that is used. Now, there are all kinds of ramifications of that. I could talk in a minute why. Maybe I should just talk now. Why do I think? Why would we have used that? Why would both of these orders be intensely finance-centric? I would simply say this, in the last 30 years, our methodology of governance in terms of dealing with, and I'm going to use the language unlawful activity rather than criminal activity, unlawful activity has become to center on the property and the financial aspects thereof. So in the 1970s, we didn't have what would be called, when you went into a bank to open an account, you didn't have to disclose all kinds of information. You do now, you have to show your IDs. All of that is financial regulation of financial activity. It wasn't in the 1970s, 60s, that wasn't happening. Now, there's much more enhanced regulation of financial activity. It's the methodology that states are doing. So for example, quick example, sanctions against US autocrats, sanctions against Russian, against some of the Russian facilitators. So these Russian autocrats that we've seen in the context of the war. Those are finance-centric injunctions against individuals, right? That's a newer strategy that's been emerging, the idea of having finance-centric restrictions on persons, right? So this has emerged, this has become more common, and I suspect that that's why, in thinking about how do we deal with this disturbance, this thing that we've decided has amounted to an unlawful, that we have this instrument which is to tether folks' finance, and that's exactly what we did. So, as I said, everything we did and everything done with respect to the emergencies from the invocation to the end is circumscribed by law. So, in the Emergencies Act, once we've declared an emergency, Section 19 tells us the powers we have. So just in looking at that is, all the powers we have for different emergencies are different. There's no limit on the powers you can use for a war emergency, but for public order emergency, you have to find your power. If you're going to do something, pass a law, it's got to be in Section 19. So the only thing I would do is to challenge you to take a look at Section 19 and say where within you find the power to regulate someone's bank accounts. Now I say that, why is this important? Why would this be crucially important as to whether these powers? If a power isn't outlined in the emergencies law, right, then it was unlawful, right? So I simply pointing out that Section 19, if you look at some of the things we did under those regulations, we regulated prohibited public assemblies. That's what happened under those two regimes. Public assemblies were prohibited. We restrained travel, right, to and from the country. If you go beyond that, we designated certain public places, right? We authorize, if you look down at D, right, authorize people, right, the rendering of essential services, right? All of those things happen. But the only place where you see property mentioned is 19(1)(a)(3), the use, so the regulation or prohibition of specified property. And if you had asked me in 2019 if I thought to look at this and to say whether I thought the use, regulating or using the special use of property had anything to do with our regulation of the way we regulate terrorist finance activity, had anything to do with money laundering regulation, had anything to do with any of this financial regulations, I would have smiled and I would have said, no, I think that means, you know, maybe you can't bring gasoline tanks. But I never would have conceptualized. So just in thinking about this, when you think about and this is how things are regulated, but when you think about this, you have an entirely healthy finance-centric model that it's got to be predicated on law. So the law has to be here. And the idea would be the only law, you know, I've been wrong so many times it's not funny, but the only piece I would say here that it might be centered on would be section 19(1)(3), the specified use of property. And I think that's a hard sell, a very, very hard sell. So, in conclusion, I want to highlight, I just want to say a couple of things sort of before leaving up, sort of opening it up. I think it's important to remember that there's a rule of law, that the rule of law sort of was active, right? The rule of law was there before the Emergencies Act. The rule of law was relevant to that exercise, whether we can debate about whether you think it's legitimate or not. You can look at the standards there and we can argue specifically about those, right? So it shaped all of that, right? And I think those debates continue. When I say those debates continue, there are currently actions, right, in the federal court which are specifically about the invocation, right? There are actions in the Ontario provincial courts that deal with it. So all of these actions are ongoing within the Canadian courts. But I can't sort of conclude without mentioning this. I think I alluded to it earlier. This entire, the sort of the way in which we, I guess as a country decided to deal with this through these particular temporary measures, which were so intensely finance-centric. Why do I find that particularly worrying? Well, first, as I just said, I'm not sure it sits within the powers we actually had under the Emergencies Act. But secondly, and I think maybe many of you will be aware of this, there is a decidedly worrying global trend of dealing with civil society organizations. So civil society organizations meaning maybe an advocacy group, maybe a human rights, a group that's talking about promoting human rights, a group that sort of promotes, say, political dissents. There is a disturbing trend of silencing these groups, not directly. So not necessarily outlawing them or not letting them in the country or doing anything else, but of actually silencing the group by tethering their resources. So when I say that, what I have there is, that's a human rights report from Human Rights Council from 2022. That report, I thought I was going to be looking at it for the right to protest, right, or the right to public assemblies, specifically a report on access to resources in the context of civil society organizations. That's what it's about. So not about the balance between, protesting and assembling, right? But it's specifically about the access to resources. And as you know, right, the mobilization of anything requires resources. Nothing is accomplished without some kind of financial basis, right? Some kind of donation, some kind of anything, right? You can't go to school unless you have some kind of finance underpinning it. So a worrisome, I think, piece here that kind of goes along with what our use of the Emergencies Act in this particular way is this idea of going at or of specifically tethering or tightening or harnessing those financial resources as a way of disrupting or controlling or dealing with this particular activity. Because as I say in those final brackets, in the last 30 years, pretty much, these kind of, the tethering of property and finance has happened under the rubric of going after terrorism and terrorist financing, money laundering, and serious crime. It hasn't sort of gravitated until latterly into this sort of confusion between, say, terrorism, terrorist financing, and civil society groups. Now, to me, that's extremely, it's extremely concerning. I don't think it's an easy task always to discern between those, but I do think it's a very troubling global task. And I just want to conclude, I want to say one thing at the end, which is what I noted at the outset, the importance of the international dimension, right? And the importance of this thing getting that kind of global reach. I think that when we think about, this is a human rights report. So when you think about Canada's legitimacy and Canada's voice and Canada's authority in international law, the ability to call another state to account, right? Say, point out another state what it's doing wrong. It's heavily dependent upon your own domestic compliance, right? So there's rules in international law, but the extent to which you actually as a state respect and respond and comply is part of your authority, right? It gives you that voice. So one of the concerns I have here is that Canada, some of the coverage of Canada, it's not about our legitimate voice as sort of this place that's advancing human rights. It's more about here's here's the Canadian model of dealing with a protest or with political dissent. We're just following Canada because by going after the finances. To me, that's very extremely concerning. So on that note, I'm very grateful, grateful for your attention today. I thank everyone for their interest. I thank, again, thank you to the Mauro Institute. Thank you for Jason in particular. Great thank you to Gabriel Thomas for a lot of the research that went into this and helping with that, and for all of you who are here for facilitating. And I would welcome your questions or particularly your comments on any dimensions of this. So thank you so much.
Hi, I'm Tara Shepherd-Longcoat. I really enjoyed your talk, and I made sure I made time to come in on Zoom today to hear it because my PhD research right now includes research on the Convoy and how can we have those peaceful, nonviolent social movements, but also really protect people who are harmed by the violence in many of these movements like the Convoy. So my question and comment was the decision makers like Trudeau and at Inner Circle would have made the decision to vote the act. They would have consulted lawyers before invoking the act, and they would know from your presentation that they'd have to have a commission later to be accountable. And I totally agree with you on accountability and being careful to not misuse law. Having gone to a lot of terrorism study seminars around the world, I've heard a lot about the importance of limiting terrorist activity and organized crime through property-centric models because it can help de-escalate things like terrorism. And there are many folks who feel like the Freedom Convoy is white terrorism, largely white terrorism. Many people of color, many folks that I know in Ottawa and as well in Steinbach. I have an office there here in Manitoba, which is a ground zero for Manitoba Truckers Convoy. And I see them all the time, including at LGBTQ events. Harming LGBTQ people at the events through what they say and do at these events. So for me, the invocation worked and it dispersed the protests mostly peacefully, and no dictatorial regime in Ottawa like Russia, it followed that. So my question is, do you think there can be a balance between being aware of the misuse of the act, like a balance, but also remembering we're here to also, with the charter and with the criminal code, to protect communities, especially oppressed communities like 2S LGBTQ plus who feel really frightened and harmed by the Convoy, especially lately here in Winnipeg with the 1 Million March for Children.
Sure. I think one of the interesting pieces you brought out there is this sort of a center would be this idea of look, when we focus, which is fair enough, on that property dimension. So it's a less antagonistic model. So somebody said, look, if we hadn't focused on property, so let's say you agree that it's gotten out of hand and that these serious harms are happening, that it's a less evil, a less harmful methodology, rather than sort of sending in an armed police force, rather than calling on civilian authorities, would be to begin to squeeze people's money because so the money doesn't die. So if somebody's actually injured in once the Emergencies Act has been invoked and they're injured or harmful, right, that physical military police action can cause harm, obviously. And one of the ideas would be that a value, I suppose, of using a different method of focusing on property, it's going to be a temporary harm. So and in saying that, a lot of people's finances were disrupted, but by and large, money was reasonably relief. So if you set those two alongside, what could we have done versus, you know, what could have been the response, and we could have just said, you know, prohibited it and used force, physical violence, which has its, you know, all kinds of sort of inherent dangers. But in this particular case, we were less reliant on that and more reliant on money as a way of squeezing. It's sort of a gentle, it's coercive in a way, but it doesn't cause any kind of enduring harm. There's certainly that argument. My only concern though, and since we're talking about, because when you're raising all these concerns about sort of advancing the rights of different groups and organizations, I guess my huge concern is that there's been the shuttering of, say, human rights organizations that are specifically centered on, you know, the rights of gay and lesbian peoples, right? Specifically, the human rights organizations have been shut down in different countries, right? By shuttering their finance, by claiming they are, you know, sort of engaged in this kind of unacceptable political dissent. So I think that there are just concerns, all kinds of concerns that sort of infuse the matters that you're raising. Right?
I have a question. So I'm persuaded about the intensely finance-focused actions that happened in Ottawa around the invocation of the National Emergency Act. But I'm curious if you saw or you see the same kind of intense finance-focused through other mechanisms in other parts of the country, like in Winnipeg, at the border, in Coutts. Like, do you see another variety of the same finance focus in other parts of the country?
I guess I would say I'm not sure when I know that there were 165, say, bank accounts seized. I don't have a sort of a geographic portrait of where they were. I have a sense that they were mostly in Ottawa. So I haven't actually, and I don't think in reading the report on that report on financing, and there doesn't appear to be sort of the enforcement of those finance-centric pieces, in particular in Winnipeg. But then again, I would say, look, if you read the report too, you will find out that at the ministers' meeting, and again, this is at the ministers' meetings, you have Winnipeg sort of saying, look, we think we've got it under control. You have different places saying, you know, so this is why I say that there's this law, you can see them. So maybe if it's done here, if it's resolved, people were leaving, right? There was no need for those. But I don't have a, like I said, I don't have a geographic distribution of where those were used. But certainly there were places that, like I said, in looking at specifically at you know, the Premier saying, basically we don't have this, whatever your issue is, it's not sufficient here to raise our hackle, so we wouldn't proceed in the direction. It seems to be saying we wouldn't do what you're doing, and it may be because we just don't have that issue here, right? The borders have been freed, they've legitimate process is allowed to happen, and so is trade.
Can I ask a question if I could?
Sure.
I'd really love to hear your reflection on the notion of financial freezing as an act of nonviolence. If I could tease out from what you said, there was a sensibility that other more violent measures could have been used under the Emergencies Act, and the idea of doing this digital sort of, you know, control mechanism, which, as you alluded to, it being temporary and not being enduring, was a form of response that would be classified as a nonviolent form of response. And I'd be interested to hear about what you would see that in terms of the delivery of the law.
Well, certainly, some of the applications people have argued would actually amount to or tend to amount to violence. But I think, as I said, that even in control, it doesn't matter what you're controlling. The focus on finance is going to be inherently less violent, less harmful. And I say that because all of and any kind of police organized response or military response, even if it's sort of, you know, walking down the streets, tends to invite physical harm. Yeah. And physical harm can't be, you can't sort of fix it later. You get compensation in law, but that's it, it's not. So this idea of, I've never actually specifically thought about whether I contemplate these financial regimes and do they fit within the definition of violent or not. I would simply contrast them with other policing or military methodologies. So even in the context of, as I noted, in the context, whether you want to sanction Russia or whether you want to sanction America, it doesn't matter. But if you sanction, the idea of sanctioning is less violent, at least in theory. So the law of sanctions has gone a bit sideways and has demonstrated some very scary things. But one idea would be, look, if we're not invading, we're not going in with military force, we're not bombing, right? So just this idea that in terms of that kind of overt violence, this kind of sanctioning of individuals holding their stuff, right, capturing their stuff, whether it's in London, whether it's in Vancouver, right, is inherently less likely to provoke violence, to constitute or cause physical harm than other strategies. And that's the reason in the international context, sort of when we talk about restraining sanctions on states, it was originally this idea that, this is not as bad as blowing folks up, right, as war, right? Now, as it turns out, if you look at the impact of sanctions in particular, they have horrific impacts on at the individual level, right? So that is a harmful piece. It's still, maybe it's debate on this that we're sort of taking into a national context, but just in thinking specifically about the mobilization of this finance-centric methodology, I don't think it's been used. My concern in part is not so much this distinction between whether it's violence, the violence or not, but my concern would be that we've used this finance-centric strategy, which is sort of began as, look, we'll use it, it's gentle, we'll use it to tether activities, certain activities, but we've extended the range of those activities. So under this guise of it being sort of this soft way of controlling behavior, it's extended way beyond its initial ambition. So when I talk about finance-centric modeling specifically, I would mean the control originally of tax evasion, money laundering, all kinds of big, nasty, serious, bad things that have a financial aspect. That's why we started to introduce all of this regulation to capture the money that underpins serious crime, to capture the money that underpins the trade in nuclear weaponry, right? To capture that money. And so we started with that. We introduced all this kind of new regulation that we encounter on a daily basis. And that's so, and in that context, it's started, I suppose, from a decent basis, but it is migrated beyond. So that's why in this context, in response to your specific point, targeting finance is inherently going to be less violent than the military model or the policing model, right? However, that financial model has migrated beyond this context of serious criminal activity, or at least criminal activity that's underpinned by a serious financial dimension. That's the reason I refer to tax. When people think of tax evasion, it's not violent, presumably. I mean, unless you're a developing country, it's not inherently a violent methodology. But we started this policing of finance specifically to constrain the financial element because it's serious, it's expensive, right? It dilutes a lot of resources.
Would everyone please join me in thanking Dr. Gallant once again for her amazing presentation today. That I'm familiar with, so I have found this extremely fascinating, and I think that you've given us a lot to think of, and specifically in terms of the idea of that balance between the goals of peace and justice, and looking at how things can go forward with a minimum of harm. I have learned a lot, so thank you again, Dr. Gallant.